Jaden Devon Larry, and this is case number 23C4199. And we're here today on the sentencing. The jury has returned a verdict of guilty as charged of robbery and failed to make any special findings. Is that correct? The state and defense ready to proceed to sentencing?
Judge, one of the issues when the verdict was returned was whether it was a true verdict because there was no special findings. Based upon the research that I was able to locate, and I think Mr. Sullivan came with the same case law that I did. It stands for the lowest robbery. So we did look at that. So I think he's to be sentenced on a simple robbery, which is a second-degree felony.
There was no enhancements filed. No, was
I did, Your Honor. I did file a notice to seek the violent habitual felony offender. I'm not going to be doing it this time based on the case law earlier. There's some dispute about whether there needs to be a jury finding of those things or not. So out of an abundance of caution, I will not be.
You can already feel something off here. The jury says guilty but skips over critical findings. That opens the door to questions about fairness. Even the judge hesitates, which should never happen at sentencing.
all right. And prior to coming to court today, I reviewed some couple letters in support of Mr. Larry. I think they were, I don't know if they're in the court. I know there's some correspondence in the court file, but they were provided to my office.
Is it from his
From one employer I know, and one that of maybe a some sort of after school or.
While Mr. Sullivan's reviewing that, there was also some family photos that Ms. Rolak provided, if the court would like to see those.
When family letters and photos are submitted, it's always a last attempt to say, this isn't just a criminal, it's someone's son, partner, coworker. But when you see this happen, you know the defense is preparing for the worst.
I've reviewed the letters. I reviewed the letter from Ms. Rolak. I reviewed the pictures. And Mr. Meredith, anything that you and Mr. Larry would like to put on the record prior to sentencing?
Yes, as far as what you've received is basically kind of a slanted PSI towards us. So if PSI was necessary, I think you've received that information that you would have. So he has never been sentenced to Department of Corrections. So if PSI is required, I think you've got
what I would get from a PSI. So
yes.
You're willing to waive that at this time?
Yes, sir. And I believe Mr. Larry did want to put some things on the record and address the court.
Larry chooses to speak, a huge risk. Sometimes defendants dig their own graves, but sometimes it's their only chance to say their truth. Let's see what he does.
I don't want to take too much of your time up. You feel me? I know you got a busy day, but as the process been, a lot of things happened during the process, with first jury selection and stuff like that. It turned into a Richardson hearing because of a lot of evidence that wasn't presented 5 months ago after we asked for it prior up to that date. And, the Williams Rule hearing came after that. And, things were said. I think everybody could conclude that nobody said it was me. He couldn't identify me as a person. And there was no physical evidence in none of these cases, but a pair of alleged slides I was involved. And the day of the trial, more evidence came up that I didn't never see, my attorney never saw. It's clearly a discovery violation, Brady violation, however you want to call it. But, I know everybody's doing the best of their ability to make sure.
This part's raw. Larry claims discovery violations, that's serious. If the prosecution really withheld evidence, that's not just unfair, it's unconstitutional.
Everything gets seen and viewed, feel me? And I appreciate my attorney for everything he did at trial, Ms. Beasley, and as well as Mr. Sullivan. He's just doing his job, feel me? But a lot of things with the witnesses, I was expecting one to be here. She didn't show up, but I guess she got denoted or whatever. I didn't know all this to the last minute, but even at trial with the detectives saying they couldn't ping my phone, and they did ping my phone. They had a search warrant for all of this. They did a tower dump, stage 1 and stage 2. I was never in the location. So it was just a lot of stuff that was said at trial that was actually false. And you feel me, about the hitting licks thing. I was never talking about licks. My girlfriend's name is Lex. That's probably why he said what he said. Oh, I didn't know that's what it sounded like. I never said that. I never gave any admissions or any involvement or any knowledge of the crime that was being committed. So in the process of all this happened, a lot of stuff that I didn't agree on, a lot of stuff that I felt should have been ejected on, even the speculations of the robber hopping into the vehicle that was never seen, never happened. And it was just a lot of stuff. But, Your Honor, I appreciate everything Mr. Meredith did. You know, I appreciate everything Mr. Beasley did. You know, everybody just doing their job. You do what you do to the best of your ability to be fair and impartial. And I want to thank my mom and my girl for being here as well, and everybody else.
I respect the jury's verdict because they sat through it, but I do respectfully disagree with their finding.
He's emotional but calm. He denies the crime, disputes the evidence, and still shows respect. Whether you believe him or not, you can't ignore the humanity here. This isn't a cold-blooded thug, it's someone fighting to be seen.
As Mr. Larry pointed out, you are familiar a little more deeply than the jury was because of the Williams rule hearing and then hearing the testimony at trial. Mr. Larry made no admissions. The DNA on the slide was a mixture. There was never an identification of Mr. Larry as being the person that robbed the Dollar General October 8th. To my mind, there was more than reasonable doubt. There's another time for dealing with that. The state has shown me a score sheet which appears correct, where the lowest permissible sentence is 25.5 months. Based on the facts and circumstances that you heard throughout this case at various hearings and in trial, I'd ask for the lowest permissible sentence with no probation to follow. He has 464 days credit against this.
The defense doesn't beg, they present logic. No confession. No ID. No clear DNA match. They're not asking for a miracle, just the legal minimum.
State?
Your Honor, while typically a court cannot consider lack of remorse at sentencing, the case law is clear that if the defendant testifies at trial or voluntarily testifies during the sentencing hearing, the court then can consider the voluntary statements that were made and the lack of remorse at that time. So I'm asking the court to consider Mr. Larry's lack of remorse based on his statements here today. Additionally, based on Mr. Larry's score sheet, as you can see, he's got a prior violent felony for carjacking. This is not his first violent offense. In fact, he was actually on probation for that carjacking offense at the time. So I'm asking for a harsh sentence in this case, Your Honor. Mr. Larry is not a first-time violent offender. He was given a chance the first time he was sentenced on that carjacking. Did not take anything from that. So I'm asking for the maximum 15 years.
Then the hammer drops. Prosecutor calls out Larry's past and his lack of remorse. This is a brutal pivot from maybe unfair trial to career criminal. And judges often lean toward the state when it's framed like this.
All right, this time, Mr. Larry, a jury of your peers has found you guilty of strong-arm robbery. It's my obligation now to sentence you as follows. You'll be adjudicated guilty of robbery, sentenced to 15 years in the Florida Department of Corrections. Given credit for how many days? 464 days time served. I am going to set restitution amount of $600 to Dollar General. That's reduced to a civil judgment. Your assessed fines and costs of $1,028. Those include discretionary costs of $2 of local law enforcement education, a $65 assessment of additional court cost, a $150 discretionary public defender fee payment, and a $200 discretionary fine. The fines and costs are reduced to a civil judgment. Of course, since it's a 15-year sentence, there's no probation to follow. All the fines and costs and restitution are reduced to a civil judgment. Mr. Larry, you have 30 days to file your notice of appeal. If you wish to appeal this judgment sentence, if you'd like to have an attorney to represent you, you can't afford one. One may be one to represent you at no charge. Good luck to you, sir.
Two other things.
And there it is. 15 years. No probation. No second chance. That moment hits like a wall, especially after everything Larry just said. Whether justice was done or not, one thing is clear. The system moves fast once the verdict drops.
Real quick, the restitution amount, the $600, that was something that Mr. Meredith and I spoke about. there was some conflicting numbers about the exact amount that was taken. I suggested the lowest amount so that's where that 600 came from. I believe that's been agreed to, and that's why that was submitted.
Mr. Meredith?
As a civil judgment, it's
And the other thing, Your Honor, the state at this time would consolidate the other 3 cases that Mr. Larry has.
He's released from whatever bonds are on those, and those have been consolidated.
he has family locally. If you'd like to be held in PCI, if possible.
No, it doesn't. I guess.
I would just recommend the Florida Department of Corrections house Mr. Larry closest to Bay County.
But can you put on record that you?
They're already talking appeal, and they should. This whole trial seems riddled with holes. But appeals are uphill battles. For Larry, this might be his last window to fight back.